let us say to the Tahsildar, RDO and District Collector. Then, as per the judgment of the Supreme Court in Salem Bar Association 2 case, Tahsildar, RDO and District Collector. Then, as per the judgment of the Supreme Court in Salem Bar Association 2 case, Tahsildar, RDO and District Collector. Now the recording is playing. So as per the judgment of Supreme Court in 2005 in Salem Bar Association 2 case, the government is bound to give a responsible reply. The Supreme Court said that the government has to appoint one officer to give a proper reply, and that officer will have to issue a notice, reply notice, with the correct state of affairs relating to that issue. He cannot suppress anything which is favorable to the party who issued the notice, and he cannot also forego the interests of the government while issuing a notice. It should not be a notice merely to deny the allegations in the notice got issued by a citizen. Therefore, please note that whenever you issue notice under Section 80, the reply should be verified whether it conforms to the directions of the Supreme Court or not, and if not, you can take advantage of the same during trial. And with regard to array of parties, Order 1 says that no suit shall be dismissed only on the ground that party was not added, but at the same time, necessary parties have to be added, because if somebody executes a document and you are challenging the same, parties who have to be sued on that aspect should be added as parties. Similarly, in partition suits, all the sharers have to be added. And in some cases, as I told you, you may have to seek the permission of the court to file a suit for another relief, and confining yourself to the reliefs which you require now. That is Order 2, Rule 2. But if you don't seek such permission, then a subsequent suit is barred. So therefore, these are some of the preliminaries while framing a suit. And with regard to a plaint which is based upon a transaction which, according to the plaintiff, occurred due to fraud, misrepresentation, etc., you have to gather the details and incorporate in the plaint. My sister yes, my sister obtained a gift deed from my mother in a fraudulent manner. It is not valid, therefore it may be cancelled. That is not sufficient. You should narrate the entire set of facts which according to the plaintiff led to the execution of this gift deed. You may say that even prior to this gift deed, she was given property, and when the mother became very, very old, on the pretext of looking after her, the daughter had taken the mother to her place and got executed a document without informing the brother. And what was the physical and mental status of the mother at that time? All these things, as per the instructions of the plaintiff, should be incorporated in the plaint. Ultimately, if you want to adduce evidence with regard to this fraud, misrepresentation, or coercion, or all other aspects in plaint, without a pleading, you cannot adduce any evidence. On the basic facts of the case, the plaint should contain all the facts which need to be proved in the suit.
Please continue, sir.
Yes. I'm having some slight problems. So you should remember this particular principle that no amount of evidence is useful if there is no corresponding pleading on that aspect. Second thing is, while dealing with Section 7 of the Old Indian Evidence Act or Section 5 of the Saksha Adhiniyam, I stressed on the importance of knowing the origins of the dispute between the parties. Even for a money transaction, you can mention they are neighbors. Defendant stayed near the house of a plaintiff. They got acquainted, and defendant, for the sake of his daughter's marriage, borrowed money or some such thing. They are not empty or unnecessary pleas. They are necessary to be made. If you remember, occasion, cause, or effect, whether immediate or otherwise, all these things are relevant facts. Under what circumstances a particular incident occurred, these need to be incorporated in the plaint or the written statement, as the case may be, because that will ultimately come to your rescue when you are building up a case on facts. Please remember that on the basis of facts, you have to build up your case and convince the judge. Case law is something which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, which will come at the end of the case, But narration of facts should be such that there is a sequence in the narration of facts. There is an introduction of the parties initially, how the dispute developed, and how the plaintiff is driven to the court, or if it is a written statement, as to under what circumstances the plaintiff has come forward with a false suit. Therefore, it is the narration of facts, the eliciting of facts in the first instance, and a proper narration of facts, which will create an impression in the mind of the court that what you are narrating appears to be probable, because ultimately in civil suits probabilities are important. So these are some more facts relating to narration of pleadings. Yesterday we have considered promissory note suits. Sometimes defendant may say, I have paid, or in some other way plaintiff received, set off should have been given, and he may say that you have to plead set off in the written statement, or sometimes there may be a counter claim. So these two aspects also need to be noticed when you are drafting a written statement. Mostly in money matters, these issues arise. In commercial transactions, when you are dealing with a suit in a commercial court, basing on a contract, there may be a set-off or counterclaim. You have to take instructions and incorporate in the plaint, and you may have to pay court fee on counterclaim. As far as other types of suits are concerned, let us today discuss the issue of suits for possession, which fall within the scope of the Specific Relief Act. Specific Relief Act mentions suit for specific possession of specific immovable property and suits for possession of specific movable property. Movable property suits are very few, but let us take up immovable property. The suit has to be filed within 12 years of dispossession. That is the limitation. And a summary suit is also provided under the Specific Relief Act. That is Section 6 of the Specific Relief Act. It is a summary remedy, and a suit has to be filed within 6 months of dispossession. As I told you, sometimes limitation is provided in a particular enactment, even though it is not specified in the Limitation Act. Therefore, Section 6 provides that you can file a suit within 6 months of dispossession, and there is no necessity to prove your title. You are simply dispossessed forcibly, and you are seeking to be put in possession again. Of course, this type of suit is not maintainable against government or some corporate, statutory municipal corporation or something. But otherwise, between private parties, you can file a suit for possession as contemplated under Section 6. The relief is only possession. You cannot ask for declaration of title. when you file a suit under Section 6, though you may mention that you are in possession as of right and you are forcibly dispossessed. Now, when you are seeking possession, there are basically two types of suits. One is if you think that your title has been challenged by the person who has dispossessed you, or he has created a cloud over your title, then you seek declaration of title and possession. If you think that the person who dispossessed you has no title at all, and you need not seek declaration of title, then you need to seek only the relief of possession and mean profits for the period of unlawful possession by the defendant. Now, in the suit for possession alone, even though you are not seeking a declaration of title, still you plead your title and say that defendant without any manner of right dispossessed you. Maybe he is an adjacent landowner, or a licensee whom you allowed to be there. So, proof of title is pleaded in the plaint, but since there is no necessity to seek the relief of declaration, you don't seek such a relief. You will only sue for possession. But if it is declaration of title and possession, you have to prove the title. Burden is on the person who seeks such a declaration. And therefore, you have to prove your title by of registered documents or land records, or sometimes the declaration of title and injunction only involves the plea of adverse possession. Sometimes the declaration of title is only on the basis of possessory title. Possessory title is also recognized under law. And one of the main ingredients of possessory title is that the person who claims possessory title comes into the possession of the property in a peaceful manner. He will not take forcible possession. He comes into possession of the property in a peaceful manner. So this is a necessary plea which has to be there when you seek declaration of title on the basis of possessory title. If you go through the commentary under specific relief act, say section 5, you will see this concept. There are judgments also as to the ingredients of possessory title and the plaintiff coming into possession in a peaceful manner. And incidentally, you please also note the several types of possession which are discussed in the specific relief act. Lawful possession, unlawful possession, legal possession, juridical possession, a tenant holding over, a tenant at sufferance, all these concepts you need to know when you are dealing with a suit for possession. Lawful possession, of course, it's a possession supported by the right to be in possession of the property. Unlawful possession is without any right, enter squatting on the property. Permissive possession is also there when you are a licensee. And all these types of possession need to be determined in the suit. On the basis of what? On the basis of the criteria that is explained and expounded by the Supreme Court in Shanmugam versus Arya Vaisya case, 2012 Supreme Court, which I told you in the beginning itself. You can browse Shanmugam versus Arya Vaisya, 2012 Supreme Court, it will come, and in that judgment, Maria Margarita is referred. Therefore, both these judgments will give you an idea as to what exactly should be proved for proving your title or your entitlement to possession. Whether there are documents of title, what are the documents of title, in whose custody they are, who is in possession, is his possession legal, all these aspects are discussed in those judgments. And please remember that the Supreme Court said that ultimately trial of a civil suit is a journey to discover the truth, and the Supreme Court also used the motto అంటే దీక్షావాక్యం తెలుగులో motto that is on the emblem of the Republic of India, that is Satyameva Jayate. Therefore, it is not as though you have said something, the other side said something, and therefore comparing both. That is not the manner in which a civil suit is decided. And ultimately, the court will have to make efforts to know the truth, even if it involves certain measures by the court as contemplated under Section 30 CPC. Therefore, please go through that judgment also before you draft the pleadings and conduct the case, because that contains general directions as to how the court should arrive at a finding in cases relating to nature of possession. That will be useful in interlocutory applications also. So this is one aspect which should be borne in mind when you conduct civil suits. And so also the judgment in Rahul Shah case, when you need to properly get the suit schedule property identified. And if necessary, a receiver is appointed so that the defendant does not go on meddling with the property or creating interest in third parties. So these are some of the aspects when you file suits for possession. And another important piece of law is there may be two parties, plaintiff and defendant, both claiming under deficient title. Both of them do not have absolute title. Then the principle is to favor the person who is having a better title in between these two. So the court will look to that, because sometimes, even though these two people do not have absolute right, somebody else may be a paramount owner and the paramount owner is not interested in this property, but the dispute is between these two, then the court will look to the better title of one of these parties in the suit. As I told you, all these aspects that I have spoken to will be discussed in the specific relief act, and we will also find these rubrics in the digest, like quinquennial digest or annual digest on specific relief act. And you should also be aware that with regard to vacant site, possession is made out by proving title. And with regard to agriculture land or house property, you may have certain documents to prove the title. Just 1 minute. So therefore, purchase a good book on specific relief act, good commentary like commentary by J.C. Subbarao or some other commentary published by a renowned publishing house like Eastern Book Company, and then just go through what subheadings are given under Section 5, Section 6, Section 34, and a detailed subject index at the end of the commentary. My endeavor is that even if you spend, say, some 10 to 15,000 on standard books, you should be able to refer to those books, find out the solution which you want, find out the concept of law which you require to know, and stand on your own legs. That's why I'm referring to the necessity of looking into standard commentaries on each subject. Now, with regard to suits for injunction, there is a popular impression that prima facie case, balance of convenience, and irreparable loss, they are to be made out for the decreeing of the suit also, which is not correct. These three principles are considered at the stage of interlocutory application to grant injunction, not when the suit is considered after trial. These three principles come at the stage of temporary injunction, and the plaintiff has to prove prima facie case and any one of the two ingredients, that is irreparable loss or balance of convenience. Now let us discuss the necessity of filing an injunction suit relating to immovable property on a particular set of facts. Plaintiff according to his version, is admittedly in possession. Then, as I told you, what was the occasion for the plaintiff to come to court? Why is he seeking a permanent injunction against somebody, though he is in settled possession? Then, while taking instructions, you should ask your client, is he somebody related to you? By any chance, he is having your title deeds because of deposit of title deeds by mortgage or some other security? Is he your neighbor trying to encroach into your property? Is he claiming under an agreement of sale either executed by you or forged by him? So, depending on the nature of the case, nature of the facts, and the further inquiry made by you with your client, you have to seek the relief of injunction against the persons who are causing threat to the possession of the plaintiff. There is nothing wrong in adding all those persons who are trying to cause threat to the possession of the plaintiff. In while drafting an injunction suit also, you can definitely make a mention about the nature of title of the plaintiff, mode of enjoyment. Mode of enjoyment is very important when you are seeking permanent injunction with regard to immovable property. Plaintiff purchased 2 acres in 2022. He is in possession. Defendant is threatening the plaintiff, hence permanent injunction may be granted. That should not be the pleading. Plaintiff purchased, he took possession as per the sale deed, he has been cultivating the land by himself or through his agents, or he has given the land for lease. The defendant who wanted to purchase the same land and who is a neighbor of the plain scheduled property is trying to encroach into the land, stating that measurements were not taken. So all these concomitant facts which have given rise to the suit and the mode of enjoyment. If you are not able to cultivate that land, that should be mentioned as to why you are not cultivating. Is it due to lack of irrigation facility? Or is it due to the land not being cultivated prior to your purchase and full of bushes and all that? So whatever are the facts which will probabilize your case should be pleaded, and most importantly, mode of enjoyment of the property. And if there is any document like adangal which proves your possession, or payment of house tax, payment of electricity bill, all these things should be mentioned and proved in the suit so that the enjoyment of the property by the plaintiff is made out. And you should know, if the injunction suit is decreed, there is no limitation for executing the suit. and it can be executed against the LRs of the defendants also. And the mode of execution is under Order 21, Rule 32. So therefore, sometimes a properly drafted and conducted injunction suit, if decreed, would go a long way in protecting the interests of the plaintiff. If there is a forceful dispossession, if the plaintiff is unable to resist the defendant, then you have to go for a suit for possession. And what about the government taking forcible possession? You have been in possession for the last 20-25 years. The period of adverse possession as against government property is 30 years as per Limitation Act. But you have been in settled possession, as I told you, have entered the property fully, and you have been in possession of the government property. Then also the Supreme Court said, government cannot summarily evict you under an enactment like Land Encroachment Act. It also has to take recourse to the law to dispossess you. Therefore, these are some of the instances where injunction suits are filed or suits for possession are filed. Now, when you are seeking a relief of injunction or declaration with regard to easementary right, you have to be sure as to what type of easementary right you are asserting. Is it an easement of necessity? Is it an easement made out by prescriptive right? Is it a customary right of easement? All these things have to be specifically pleaded in the plaint, and appropriate relief has to be sought. You should also remember that section 60 of the 65, please browse section 60 of the Easements Act, madam. 50 or 60, I'm not quite sure. So there may be an irrevocable license granted to the person in possession to enjoy the land. This irrevocable power of attorney can be traced to that section. And incidentally, sometimes the land may belong to X, the construction may belong to Y. This is called dual ownership, DUAL, dual ownership. For example, there is a piece of 600 square yards of land belonging to two brothers. One brother has filed a suit for partition and separate possession. But even prior to that, the other brother had constructed a building in the land. The building need not be divided into half. The building still belongs to the person who constructed it. This principle of dual ownership is recognized by the courts in India. And the construction of a building under an irrevocable license is recognized under section 50 or 60 of the Easements Act. I think it is 60. Sridevi garu, you are online. Mr. Fani Kumar.
Yes, I am here, sir. I am here, sir.
50 or 60 of Easements Act, please.
Yes, sir. Yes, sir. Ippude, sir. Section number, sir? 50?
60 అనుకుంటాను 60 చూడండి 60
60.
60
License revocable.
Yes, 60.
Yes.
So that is the section which may sometimes have a bearing on the nature of possession claimed by a person under an irrevocable license. So,
May I read it, sir?
మీరు చదవండి.
ఒక్క నిమిషం, sir. Search చేస్తాను. License when revocable. A license may be revocable by the guarantor unless it is coupled with a transfer of property and such transfer is in force.
గ్యారంటర్ కాదమ్మా, గ్రాంటర్.
Grantor, sir. The licensee acting upon the license has executed a work of a permanent character and incurred expenses in the execution.
Revocation express or implied. So section 60, you please go through the case law under section 60. And therefore this may be one of the grounds on which a person may plead that he has been given a irrevocable license by the grantor. So these are some of the provisions relating to suits for injunction. And as I told you, the principle of dual ownership of the site by one person and the structure by another person is recognized, and you can straight away go to Google and type on the dual ownership of immovable property, and you will get certain judgments on this act. And there is a direct judgment on the facts stated by me. That is, a person suing for possession, the court said, even though he is entitled to half of the site, he cannot claim half of the building on the ground that the building was constructed in the joint site. So these types of cases may be rare, but all the same, and they are important. We have covered briefly the suits for possession and injunction. We have also covered briefly suits on the basis of pro note. Now, as far as suits between landlord and tenant, lessor and lessee, the rights and liabilities of the parties are narrated in the Transfer of Property Act. As I told you, the lease may be from month to month or year to year. If there is a registered lease deed and a period of lease is mentioned, the lease expires by a flux of time, that is, the time stipulated in the lease deed is over, and the landlord can seek possession of the property. And if the tenant is holding over, then he is liable for payment of damages as laid down in the judgment of the Supreme Court in Atmaram Properties. Please note Atmaram Properties, if you type the judgment will come, and also Supermax International case. The old rent agreed upon in the lease agreement is not the amount that should be paid by the tenant. And apart from efflux of time, the landlord may also issue a notice determining the lease on certain grounds available to him, or it may be a wasting of property, or it is subletting without the consent of the landlord, or whatever it is. As far as the suit by a landlord under Transfer of Property Act is concerned, the tenant has limited rights, and therefore when once the period of lease expires, it is not extended, defendant is asked to vacate by way of notice, and if he still remains in possession, there is nothing more to be proved in a court of law. Now, what happens with regard to an unregistered lease deed? You please browse for a judgment of the Supreme Court rendered in 2023. Because I am away from Visakhapatnam, I am unable to give you the exact citation. But if you just browse for an unregistered lease deed in a suit for eviction, then you will get the judgment in which it has been held that though unregistered lease deed cannot be relied upon to prove the lease, but the nature of possession can be proved, nature of the transaction can be proved. So please go through that judgment. And landlord tenant case requires an understanding of the substantive provisions contained in the Transfer of Property Act before you file a suit either on behalf of the landlord or on behalf of the tenant. And as I told you, a notice, quick notice is necessary before you file a suit. This is with regard to landlord tenant and tenant cases. Now we may come to cases for specific performance of an agreement of sale. As I told you previously, an agreement of sale will be of two types. One is an agreement which stipulates the time for performance, and an agreement which may not stipulate the time for performance, and which merely says that as and when the purchaser wants, I will execute a registered sale deed. In case possession is given under the agreement of sale, it requires registration. And an unregistered agreement of sale can be the basis of a suit as per the proviso to section 49 of Registration Act. Now, after you look at the agreement and you issue a notice, then you normally 2 or 3 aspects arise in a suit for specific performance. Whether it is an agreement which strictly lays down conditions regarding time is the essence of contract. So that is something which has to be culled out on the facts of each case on the basis of the terms and conditions contained in an agreement of sale. If the defendant takes, if the owner of the property takes a plea that it is that the time is essence of the contract for performance of the obligations by the plaintiff, then on the basis of facts, you may prove that because of defendant only the time lag has occurred, and therefore even though time is stipulated under the agreement, still the plaintiff is entitled to a decree. It is an equitable remedy, and sometimes you may have to, depending on the facts of the case, you may have to seek the alternative remedy of relief of seeking the refund of advance amount paid under the agreement of sale. As far as possession is concerned, I told you while dealing with execution, once the suit for specific performance is decreed, then possession, even though not specifically sought in the suit, can be granted in the execution proceedings, and EP can be filed for taking possession. If there is a purchaser who has purchased subsequent to your agreement of sale, he will be added as a party and he will also join in the execution of the decree document, and there should be a relief specifically on that point. And there are certain rules for drafting the pleadings. Previously, under section 16 of the Specific Relief Act, plaintiff has always been ready and willing. It was necessary to ever means plead the plaint. But now in the amendment that has been taken away, but all the same you have to prove readiness and willingness. So if you say that I am ready to take a sale deed, and the other side says, yes, tomorrow I am coming to the registrar office and I am ready to execute a sale deed, then the willingness comes. Willingness to go there and take the sale deed. If you go on postponing, the obligation which has to be performed by you, then willingness may be disproved. Therefore, readiness and willingness has to be shown to seek the granting of a specific performance decree. And only in certain cases the court will disallow specific performance. After the amendment of Specific Relief Act in the year 2018, the Supreme Court has taken the view that the Act favors specific performance rather than the alternative remedy. The amendment is not retrospective. As far as performance of a infrastructure agreement is concerned, then the person who has to execute the infrastructure contract will be given 2 months time to take up the work, failing which the plaintiff can get it done through some other agency. And an injunction cannot be granted to stop this work, stating that I have a contract I should perform it, nobody else should perform it. So these are some of the salient features of the amendment in 2018. I am speaking without the aid of any book for all these 3 days, and I would elaborate on all these aspects after I return to Visakhapatnam. Today I'm having some trouble with my throat, so if there is any interaction to be
Anyone want to interact with sir?
yes. What is the time? 7:45.
8, sir. 8.
No, sir.
Right.
Morning, madam, and good morning, sir.
Good morning.
This is Jaykar. My only interaction is to take mint water, and hot coffee or hot tea. That's my interaction, sir. Get well soon, sir.
Thank you. Thank you.
Yes, sir. Welcome.
జైకర్ వదిలేస్తే ఒక వీడియో కూడా తీసి పంపిస్తాడు సార్ ఎలా ప్రిపేర్ చేసుకోవాలో.
Sir, sure, sir.
It's only a minor disturbance.
అవునా?
Anyway, so how many of you have referred to any book which I have? Any of you have referred to books which I have mentioned? Any of you have started looking for a particular question of law in the book? How many of you have started just having a glance at the provisions of any enactment? How many of you have begun reading
Making efforts,
Bare Act?
making efforts, but not yet, sir. I've taken the list and went to the publisher also, but yet to take bring them home.
First of all, you purchase Bare Act and study the Bare Act.
Bare Acts are there, sir.
Okay, you go on familiarizing yourself with the Bare Act.
Sure, sir. Sure, sir.
So that will, because as you go on reading all those things, when I speak on certain provisions, you will be able to immediately catch up with me.
Exactly, sir. Exactly.
Okay, sir. Thank you. Today,
Thanks again,
because
sir.
of my-
Take care, sir. Take care.
Okay. Thank you, madam. I am leaving today.
Thank you so
Sir,
much.
one minute, sir.
Thank you, madam. One and all have a blessed day. Take care.
Somebody wants to ask something. Yes, please go on.
కాశీనాథ్ గారు.
Only regarding the cross-examination thing, sir. Yesterday you have advised to get Sarkar book, sir. There were 2 books. One is the 2-volume book and another is Art of Cross-Examination, sir. Which one we have to take, sir?
Art of Cross-Examination by?
Sarkar only, sir. There are 2 books available in the market. So they take hints in modern advocacy, professional ethics, and art of cross-examination by Sarkar, SP Sarkar.
So you can take that, no problem. Even in the big volume, I think it is now 7,000 and odd 2 volumes.
It's a 2-volume book, sir.
The price is around 7,000.
Yes, sir. Yes, sir. Kamal Law. It's a publication by Kamal Law House, sir. It says Sarkar's Law of Evidence. It highlights
Yes.
appreciation of evidence, circumstantial evidence, electronic evidence, proof of documents, expert evidence, and cross-examination. That is a 2-volume book, sir.
No, that is not. Sarkar Evidence Act is section by section.
Section by section.
Maybe
Okay.
SP Sarkar is not correct.
Okay.
I think it is not published. I will verify and tell you, sir. I will verify and tell you.
Okay, sir. Thank you.
Because the main book which I have referred to will have a lot of information about cross-examination. I will verify. Please don't purchase. Huh?
Thank you, sir. Thank you.
Thank you. Okay, I believe.
Get well soon. Have a good day.
Yes, sir. Thank you so much.
Sir, small doubt.